All right. Good morning, everyone. Feel free to eat while I talk. I'm going to talk to you a little bit about suspended sentences, which I think just after breakfast made me think is not unlike a suspended coffee, but considerably less charitable. We had this theme today of monopoly. Do not pass go. Do not collect your $200. Go straight to jail. And I think that analogy is quite appropriate because we like, for all of the things that we're talking about today, because we like to think of sentencing as not merely being some kind of game of chance, but in fact that we have a collection of aims and principles and they're all instinctively synthesised, and it's not some kind of luck of the draw or roll of the dice that determines our client's fate. My thoughts today in relation to suspended sentences are expressed probably sensibly in the paper that's provided. I'd rather express them outrageously and start conversation now. So I'm taking the colour and movement part of the session, and I hope you'll enjoy doing that with me. As part of that Tough on Crime initiative, we have the abolition of the suspended sentence, and there's a significant risk that our clients are rolling the dice and running the risk of being sent directly to jail, or perhaps I should say, to move away from monopoly and into our real worlds, go eventually to jail after 5 or 6 days in a police cell. Do not pass the dock, even for your own plea, and by no means should you try to collect legal aid. So I want to outline fairly briefly some of the stages of the abolition of suspended sentences. In what courts, in what cases can you still seek one? And if you think that's relatively simple, well, I suspect it is, but that's not to say that the court hasn't got it wrong already. I also want to have a look at, as well as those stages, revisit the rationale and consider what drove suspended sentences. For a couple of reasons, mainly to test the changes that we have against those rationale, but also because it's not inevitable that they will be gone forever. And then lastly, I'd like to have a look at some of the alternatives that are put forward in relation to the suspended sentence, and ask the question, and ask it particularly of you, whether the community corrections order is going to provide an adequate replacement for suspended I was always going to get that wrong once, for suspended sentences, or whether in fact we're going to find an awful lot of people going instead immediately to jail. All right, so if we have a look at the stages, you'll find in your pack a ready reckoner, which is not quite as easy to read as I had planned, but it will be slightly amended to be in a larger format when it's online, and if you would like a copy that's easier to read, then just come and see me afterwards and I'll work that out. If I go through that briefly then, prior to the 1st of November, sentences of imprisonment could be suspended for all offences as long as that was desirable in all the circumstances. For the period between the 1st of November 2006 and the 1st of May 2011, suspended sentences were available except where they were serious offences. Exceptional circumstances had to be established, and you'd be aware that those serious offences included things like homicide, rape, causing serious injury, intentionally armed robbery. Between the 1st of May and the 1st of September 2013, then suspended sentences were available as long as they were not serious and also not significant. And in the higher courts, you'd be aware that that included causing serious injury, recklessly aggravated burglary, arson, and trafficking in commercial quantity. And if an offence was neither serious nor significant, then again it had to be desirable in the circumstances that the sentence be suspended. But that involved now considering the adequacy of denunciation and deterrence in providing that sentence. Now, for a while there we had a loophole in which a matter referred from the county court where the suspended sentence was not available to the magistrate's court could result in a suspended sentence. That loophole is now closed. From the 1st of September this year, no offence dealt with in the Supreme or County Courts can result in a suspended sentence. The Magistrates' Court can until September of next year, unless that date changes. still suspend sentences for offences that are not serious or significant. And come September next year, no court will be able to suspend a sentence of imprisonment at all. So let's have a look then at why we abolished the suspended sentence, and also have a look at that replacement of the Community Corrections Order. The Sentencing Advisory Council identified a number of perceived concerns amongst the general public with suspended sentences, and I suppose I've simplified them somewhat for today. I think that it's worth looking at them and asking the question, does the Community Corrections Order deal with these particular concerns? And keep in mind that our suspended sentence has come and gone over time in Victoria and in other jurisdictions as well. So it was introduced in Victoria in 1919 and then disappeared in 1958. Reappeared again in 1986, was modified in 1991, was modified again in 1997, and then in 2006 was recommended for abolition. It's come and gone in New South Wales. It's come and gone in New Zealand. All right, so let's have a look at these rationales. The first one we'll have a look at is that idea that jail should mean jail, the idea of truth in sentencing. And related to that was the concern that the gap between an immediate sentence of imprisonment, which was a real punishment, and a suspended sentence of imprisonment, which was getting off scot-free, was too wide. And perhaps we should attach conditions to the suspended sentence or something like it to narrow that gap. Also considered as a concern was that suspended sentences were inappropriate for sexual offences. Now, most of you would know that, in fact, they were not used significantly for sexual offences, but that doesn't mean it wasn't very important to the Victorian public to make that clear. Now, alongside our abolition of suspended sentences, we have the introduction of the Community Corrections Order in January 2012, which provided, or was meant to provide, an alternative to the suspended sentence, in addition, of course, to being sent immediately to jail. The government's been at pains to declare that the removal of the suspended sentence does not lessen sentencing options available to the sentencer. But experience in other jurisdictions demonstrates that when a new non-custodial sentence is introduced, like the Community Corrections Order, they're primarily given to offenders who would have received a different non-custodial sentence, and that in fact custodial sentences are rarely replaced by non-custodial sentences when they're introduced. Now, given that our suspended sentence was only ever given once a custodial sentence was justified, and that the Community Corrections Order has already effectively replaced both the community-based order and the Intensive Corrections Order, then I think there's reason to expect that a significant proportion of those who would previously have had their sentence suspended will instead go straight to jail. My assessment is, and yours may be different, and I would appreciate hearing from you about it, is that the Community Corrections Order is currently being used to sentence those convicted of serious and significant offences, armed robberies, aggravated burglaries, causing serious injury, but primarily where the offender is young or has a lack of priors or good prospects of rehabilitation, and the judge wishes to protect that offender from the contaminating influences of prison, which I think leaves that concern that for other offenders there's that significant chance of being sent immediately to jail where otherwise they might have had their sentence suspended. Jail means jail also, I think, begs that question, which jail would that be? I know that we've all experienced a variety of difficulties with our overcrowded jails. We don't have Ravenhall available until at this stage 2017, and although that now is going to be built to accommodate 1,000 prisoners, 700 of those places have effectively already been spoken for. We have 35% of prisoners currently in shared cells, sleeping in camp beds in communal areas, or being assessed for their suitability for accommodation in caravans. In addition, you know that we have every day in police stations 200 more people than the police can actually cope with, and that's not accounting for the 2 rapists in Bendigo who slipped away from them. There's been some data from the Sentencing Advisory Council in relation to the increase that we can expect in imprisonment rates. There's been no increase since the changes in November 2006, but the changes that have occurred from then until now are clearly much more significant. What I think we can do, though, is to extrapolate from prison data and say that if every person who was sentenced to a wholly suspended sentence in the higher courts was now instead to be sentenced to immediate imprisonment, we'd have a 50% increase in the number of convicted prisoners in jail. Now that reflects roughly the New Zealand experience. When they abolished suspended sentences in 2002, they had an immediate 23% increase. Now it may well be that a number of those people only get fairly short sentences, but we know that short stays cause their own set of problems. That corrupting influence of jail corrupts fairly quickly, but the ability to get onto reasonable programs generally takes much longer. We know that the Parole Board is currently denying parole at a 40% increased rate, and part of that is to do with overcrowding and the fact that prisoners are not completing rehabilitation programs before the end of their non-parole period. Now, on the other hand, if all of those people who previously would have received a suspended sentence are put on a community corrections order, what kind of increase are we going to have in the number of people on supervised orders? 100%. We'd have a 100% increase in the number of people. Last year we had 7,000 people under community supervision every day in Victoria, and as of the 30th of June this year we had 13,000 community corrections orders registered and 1,500 occasions of judicial monitoring in relation to those. So not only can we expect to have more people on community corrections orders, we can also expect that those orders are going to last a lot longer because they're replacing sentences which could have been suspended for years. Now, I'm happy to award a Freddo Frog for anyone. The longest community corrections order I'm currently aware of is 10 years. Can anyone beat that one? No, right, anyone beat that one? Okay, we'll leave that as standing then in relation to an 18-year-old man who robbed a milk bar with a baseball bat. That's a long period of supervision. So as long as community corrections is prepared for a doubling of their workload, then I don't think we've got a problem. Though I should say, the last time I checked the Sentencing Act, cost efficiency was not one of our aims, but the different price of putting someone on a community corrections order as opposed to jail is 11-fold. It costs 11 times more money to have someone in jail than on community corrections. So I don't know, perhaps that will be an influencing factor. In relation to the second factor that I have there, the second rationale for the abolition of the suspended sentence, that the gap was too wide, clearly that gap represented only the retribution and punishment of actual physical incarceration. And now I know I'm preaching to the converted. Many of us would say that the suspended sentence brought with it a significant element of punishment. Most of you would be aware of Chief Justice Bray's comments in relation to that, which are fairly eloquently put. Perhaps slightly less eloquently, one of my drug-addicted clients stated that she'd rather stay off the street for a month than have a year with the coppers breathing down her neck. So question then, does our community corrections order bridge that gap between going to jail and getting off scot-free any better or significantly better than the suspended sentence did? Well, the most popular conditions that have been imposed on CCOs so far have been alcohol exclusion zones, non-association conditions and place exclusions. I'm not sure that the community would consider them to be the most punishing of conditions, and I'm not entirely convinced they think that bridge the gap terribly well. The other factor to take into account is that the suspended sentence had a significant impact on rates of recidivism, and that those people who went to jail immediately reoffended more quickly and more often, somewhere in the element of about 30%, than those who received suspended sentences. Now, the community corrections order probably goes some way to replacing the suspended sentence in this regard, in that a breach can result in 3 months imprisonment, a fine or a forfeiture of a bond. But to be fair, 3 months in prison isn't very long in comparison to the period a sentence could be suspended, and that fine is merely a level 11 fine. If we look lastly then at the concern that suspended sentences are inappropriate for sexual offenders, quite frankly that was an overreaction because they never cracked the top 10 uses for a suspended sentence. But I think it serves as a salutary lesson to all of us that if we fail to educate the community about sentencing, then we have to pander to their misinformed opinions. It's also hard to imagine that a curfew or an exclusion on a sex offender would bring great comfort to the majority of Herald Sun readers who clearly want to have all sexual offenders warehoused. If only they understood that putting them in jail is the easy bit. It's reintegrating them into society afterwards that's difficult. All right, so having taught you all how to suck eggs, what are my predictions for the outcome of suspended sentences? And clearly I'm being inflammatory with pictures here. I think it's inevitable that more people are going to be imprisoned, and immediately, as opposed to in the future as baseline sentencing may create. I think what will flow from that is an increase in recidivism, to say nothing of lice, scabies and rioting. I think that we're going to have less guilty pleas, less early pleas, longer trials. And as for the community corrections order, well, I think it's either going to be really well utilised and disappoint the community in exactly the same way the suspended sentence did, or it's not going to be well utilised and not provide an alternative to the suspended sentence that it ousted. But I guess I'm pretty keen to hear your thoughts about that. In my house, a short game of Monopoly is a good game. So that's it from me, and let me hand you over to Greg.
Trevor, can I ask you, what would constitute substantial and compelling circumstances to justify a judge not imposing a 4-year minimum? The gross violence.
Under the gross violence legislation, there are 3 categories where the mandatory minimum is not to be applied. One is, as I said, if a person aids and abets, counsels or procures the commission of the offence. The other is if they're under 18. And the other is if the court finds a special reason. Now, special reason has a very large definition under section 10 capital A, and that can be impaired mental functioning, and there's a great definition of what that means. If there's a hospital order, if they prove that the impaired mental functioning would result in significantly more burden in prison, which is really a burdens type application. And then there's a general that there are substantial and compelling circumstances that justify not imposing that 4-year minimum. That in itself has another subsection which talks about what that means. And in determining whether there are substantial and compelling circumstances, the court must have regard to 2 matters. One is Parliament's intention that ordinarily a 4-year minimum should be applied. But secondly, whether the cumulative impact of the circumstances of the case would justify a departure. Now, there's no definition other than that, if you can call it that, of what substantial and compelling circumstances are. But perhaps this is where we can be creative in a plea circumstance, that cumulative impact, again, that's not defined, but in my view, perhaps what we do have is definitions of various definitions and interpretations of what exceptional circumstances are in bail and in breaches of suspended sentences, etc. So, in my view, a cumulative impact must mean that a judge has to look at all of the circumstances, and we have authority that talks about that, and not focus solely on whether the circumstances are unprecedented, as you would in a exceptional circumstances case. So That's a long answer to that, but in my view, we can draw on the exceptional circumstances. It may be that when you look at those phrases, cumulative impact, in my view, that's a lower level than exceptional circumstances. So I think there's a lot of scope to avoid this minimum, and a decent judge, you know, sentencing or faced with sentencing a young person who is otherwise facing a 4-year minimum, there may be a number of reasons that you can cobble together to avoid that sentence.
Yeah. Marita.
There's another question for Trevor.
Well, just perhaps
I can speak loudly.
Good.
How far in advance is planned in advance? That morning or the day before or 25 minutes beforehand when you've drunk 26 Red Bull vodkas? How far? What's the memorandum say?
Yes, the question, in case you didn't hear, was how far should a planned in advance be to engage in conduct or planned conduct of causing a serious injury? I don't know. It's odd. This whole area of complicity is very odd in this section. But as I say, and perhaps it might just be a very easy way to answer this is to repeat what the section says, that it can be 3 different circumstances. The planning must be in advance and engage in conduct, and at the time of planning, the 3 circumstances are: the offender intended the conduct would cause a serious injury, was reckless to that fact, and that a reasonable person would have foreseen that. So I imagine it would happen right up to the time of, but then you start getting into aiding and abetting and other forms of complicity, which the Crown would obviously latch onto, because then they avoid the out that you've got in the mandatory minimum for aiding and abetting. But short answer, there is no definition. But they do have to prove it. It is another element that has to be proven.
All right, let me ask another one then. You seem to have gone a bit quiet. Karen, what is the justification proffered by the government for the introduction of baseline sentences?
Well, thanks, Greg, for that question. The only justification the government's advanced is was contained in a media release that the then opposition released 4 days before the state election, where the coalition government said, and I quote, that Victorians are sick and tired of seeing offenders receive hopelessly inadequate sentences time and time again when they destroy the lives of young people with drugs or commit the most horrific of murders. And that's essentially the gist of the rationale. Of course, if the government paid attention to the research conducted by its own Sentencing Advisory Council, as well as others such as Dr Austin Lovegrove and the Tasmanian Jury Sentencing Survey, it would recognise that when the community is informed of the range of factors that a court needs to take into account in sentencing, the community no longer call for longer sentences. Sadly, the government clearly doesn't want to, or for whatever reason doesn't accept that research, and instead has pandered to the Herald Sun type approach, which Nikki's already referred to, of more people in jail for longer.
Can I ask a question then of you, Nikki, picking up on what Karen's just said? If you take the Austin Lovegrove study of informing members of the community of the circumstances of offending, is there any evidence to suggest that if you take it as the premise that generally when people are more informed about the circumstances of offending, studies have shown that they'll often impose sentences lower than those given by judges in given cases, is there any evidence to suggest that that would extend to then favouring the retention of suspended sentences?
Probably not. It would be require an education about the aims of sentencing, the costs of imprisonment and the flow-on effect of imprisonment before that would make a significant difference. But the basic idea that if you do a better job in educating the public about the impacts of sentences, that the variety of options that we use will make more sense to them and be more palatable is true. And I think that we do have a question, Greg.
Karen and Greg, just the baseline numbers for years in total for the various baseline offences, they're not set in stone yet. Is there any, haven't Sentencing Advisory Council come to those figures? Was that extrapolated out from numbers and averages? Or?
Did everybody hear the question? The question's about how, the question James asked is the baseline figures. How did the Sentencing Advisory Council come up with those and whether those figures are set in stone? To answer that second part first, those figures aren't set in stone. They're ultimately a matter for the government to decide on and include in any legislation which it introduces into Parliament. However, the Sentencing Advisory Council recommended particular numbers and figures, and you can see a full list of those is in the SAC report, which is available on their website. Anyone who was involved in the consultations with SAC prior to the publishing of their final report would know that it's a somewhat curious methodology which was adopted by SAC in coming up with those levels. In some cases, they were based on median sentences, which obviously the SAC has a whole lot of data which it analyses and publishes snapshots. And in some cases, those baselines represent the median sentences currently imposed. In other cases, the SAC bumped up the median in circumstances where it felt that the median sentence was not representative of communities' expectations of what those sentences were worth. And as I understand it, the SAC also had regard to Court of Appeal decisions. For instance, decisions dealing with the offence of aggravated burglary, where the Court of Appeal had suggested that current sentencing practices for that offence were quite low. But whatever the methodology precisely was, and whatever process the government uses in coming up with its own figures, I would suggest that one of the real problems with this scheme is that there is a real lack of transparency as to how those figures are actually selected. Interestingly, in New South Wales, where this sort of scheme has been operating for a number of years, one of the main complaints that is coming out of New South Wales by practitioners is that the scheme that's being used there has actually resulted in the community and victims of crime having even less understanding of how sentences are arrived at, because it's become this somewhat random process of you start with this figure and work around that. So I hope that answers the question. You might even have some more information about how those figures were arrived at from your own involvement in the consultations too. Yeah.
Is that it? Any other questions? No? All right. Well, if that's the case, would you join me in thanking our three speakers this morning?